Adija Palmer, Kahira Jones, and Andre St. John.
If it pleases you, Madam President,
Yes, Mr. Clark.
it's a pleasure to address you as such, my lady. For the first time, the appearances,
Yes.
congratulations, my lady. The appearances in this matter for the appellants, John Clark, Isa Buchanan, Alessandro Labiche, and Mr. Iqbal Chevalier. For the Crown, we have Miss Claudette Thompson, the Acting Director of Public Prosecution, Mr. Yannick Forbes, the Assistant Director, and Mr. Rashid Lee, Crown Counsel, are present today, and we're all here with bated breaths, awaiting the court's judgment in this matter.
Thank you, Counsel. On diverse days between the 10th and 18th of June 2024, the court heard submissions from counsel in this matter regarding the retrial, that question of a retrial that was remitted from the Privy Council to this court. At the end of the submissions, we reserved our judgment, and the court is now ready with its decision. The decision of the court is unanimous, and we have a judgment in writing, which is still subject to editing in any event because we were trying to...
Unanimous verdict. Hey, Koshata.
Is to extract a summary.
Which way will it go?
For the decision.
I really don't know today. Good evening and welcome.
Promise to release the full judgment as soon as possible. So what the court has today is a summary, which is in writing and will be released. And we have a disclaimer. This summary is provided for the sole purpose of assisting members of the public with understanding the Court of Appeal's decision in this matter. It does not form part of the reasons for the court's decision and should not be used as a substitute for the judgment of the court, which is the only authoritative
This disclaimer sounds spooky, me not lie.
Full judgment of the court will be made available to counsel and through the court's website at www.courtofappeal.gov.j. On 13th March 2024, the appellants, Sean Campbell, also known as Sean Storm, Adija Palmer, also known as Vybz Kartel, and Kahira Jones and Andre St. John, also known as Madsus, were convicted of the murder of Clive Williams, also known as Lizard. The appellants appealed their convictions to the Court of Appeal and then to His Majesty in Council. On 14th March 2024, 10 years and 1 day after they were convicted in the Supreme Court, the Judicial Committee of the Privy Council recommended that the appellant's convictions be quashed. The Privy Council remitted to this court for determination the question of whether the appellants should be ordered to stand a new trial. Over 6 days, the court comprising Judges of Appeal MacDonald Bishop, P. Williams, and D. Fraser heard arguments by counsel for the appellants on the Crown on that question. The court has considered counsel's written and oral arguments, as well as the authorities and evidence filed by both sides, and has arrived at a unanimous decision. For a fulsome appreciation of the question remitted to this court for determination, and the court's resolution of the issues and sub-issues raised by the parties relative to that question, an abbreviated summary of the background is provided. The allegations in the court below were that the deceased and Lamar Chow, the prosecution's sole eyewitness, had been given two unlicensed firearms belonging to Palmer for safekeeping. The appellant Palmer gave Lamar Chow and the deceased a deadline of 8 o'clock
Like
p.m.
and share the live,
on
please.
14th August 2011 to return them, with which they failed to comply. As a consequence, Lamar Chow and the deceased were summoned by the appellant Campbell to the appellant Palmer's house at Swallowfield Avenue, Havendale, which we call the Swallowfield premises. They went there by taxi on 16th August 2011, accompanied by Campbell, and on arrival were met by the appellants Palmer, Jones, and St. John. The appellant Palmer asked what plans Lamar Chow and the deceased had for replacing the firearms, to which the deceased replied that he would replace them. They were then both attacked, after which Chow saw the deceased lying motionless on the ground, with the appellant Jones bending over him. Lamar Chow escaped, but the deceased was never seen again, and calls to his mobile phone went unanswered. A team of police officers went to the Swallowfield premises to investigate the alleged homicide. They noticed that the house smelled of disinfectant. When the police returned to the premises on a subsequent visit, they found that the entire interior of the house had been destroyed by a fire. On a further police visit, it was discovered that the rear of the house had been demolished. The police dug at the premises but did not find anything of significance to their investigations. The appellants were taken into custody on 30th September 2011 and subsequently charged for the deceased's murder. They have been detained ever since. The appellants were tried in the Home Circuit Court before Justice Campbell, the trial judge, sitting with a jury. The trial lasted 64 days. During the course of the trial, there were three incidents involving the jurors. The first and second incidents are not relevant to these proceedings and will therefore not be discussed. It suffices to state that after the second incident, the jury panel was reduced to 11 members. The third jury incident came to light on 13 March 2014, the last day of the trial judge's summing up of the case to the jury. Following the report of possible jury misconduct, the trial judge convened a hearing in chambers and informed counsel on both sides that he had been made aware that a juror, who we call Juror X, attempted to bribe another member of the jury with an offer of $500,000 to decide the case in a particular way. The trial judge and counsel on both sides questioned the forewoman of the jury in chambers. The forewoman informed them that Juror X had spoken to all the jurors and encouraged them to free the appellants without regard to the evidence. There was no evidence to connect any of the appellants with the activities of Juror X. Faced with the possibility of having to abort the trial judge heard submissions from the Director of Public Prosecutions, the DPP, and defense counsel. Despite defense counsel's resistance, the trial judge decided to continue with the summing up and handed the case over to the jury that evening. The jury deliberated for over 3 hours and by a majority of 10 to 1, convicted the appellants of the deceased's murder on the same day. The appellants were each sentenced by the trial judge to imprisonment for life at hard labor, with the stipulation that the appellants Campbell and Jones should serve a minimum of 25 years in prison before becoming eligible for parole, and the appellants Palmer and St. John should serve a minimum of 35 and 30 years, respectively. The appellants were unsuccessful in their appeal to this court and appealed to the Privy Council. The Privy Council allowed the appellants' appeal and quashed their convictions on the basis that the trial judge's treatment of the third incident of jury misconduct was a material irregularity in the course of the trial, giving rise to a miscarriage of justice. In the Privy Council's view, the trial judge should have done more to investigate the third incident of jury misconduct. Furthermore, allowing juror X to continue to serve on the jury was fatal to the safety of the convictions and was an infringement of the appellant's fundamental right to a fair hearing by an independent and impartial court under Section 16 of the Constitution of Jamaica. Lastly, the fact that the prosecution was prepared to waive the irregularities in the trial did not absolve the trial judge of his responsibility to ensure a fair trial. In all the circumstances, the trial judge ought to have discharged the jury and ended the trial in order to protect the integrity of the system of trial by jury. Against this background, the court has to determine whether the interests of justice require that the appellants be ordered to face a new trial, or whether judgments and verdicts of acquittal should be entered. The court starts with the Constitution, which provides that upon conviction, a person should not be tried for a second time unless a court of superior jurisdiction, which is the appellate court, orders that there be a retrial. The Constitution did not set out the circumstances in which the court should order a retrial. It is to case law that the court looks to determine what are the principles applicable to the question of whether there should be a retrial. The court looked at all the applicable legal principles governing the question of a new trial, which was set out most authoritatively by the Privy Council in the case of Reed against the Queen. We will not state the citation at this time, but that is in writing. The court also looks at other principles emanating from subsequent cases since Reed, and we have an amalgamated list of those factors. There are 12 factors that the court has considered. The seriousness and prevalence of the offense, that's one. 2, the strength of the prosecution's case. 3, the availability of the prosecution's witnesses and exhibits. 4, the availability of the defense witnesses. 5, delay and whether a retrial can be facilitated within a reasonable time. 6, the time, financial costs, expense, and impact on the court's resources of a new trial if one is ordered. 7, the ordeal to be faced by the appellants if a new trial is ordered. 8, the impact of prejudicial publicity on the fairness of a new trial, if ordered. 9, whether the new trial would give the prosecution an unfair advantage. 10, changes in the Jury Act. 11, potential legislative changes in the sentence for murder. 12, the possibility of prejudice arising from the mandatory minimum sentence and minimum term before eligibility for parole. We have considered all the factors governing the court's determination of whether a new trial should be ordered, and have given due regard to all the material, submissions, and evidence presented by the appellants and the Crown. We commence by stating that the egregious nature and seriousness of the offense in this case is beyond argument. So too is the prevalence of the offense of murder in Jamaica. We make bold to say that the features of this case bear every hallmark of a deliberate attack on and barefaced defiance of law and order, involving allegations of transactions relating to illegal firearms, a killing in respect of which the body of the deceased has not been recovered, or should we say an alleged killing in which the body of the deceased has not been recovered, and interference with a crime scene while it was under the control of the police. The court is therefore satisfied that the nature, seriousness,
they're
and
going for a
prevalence
retrial.
of the alleged offense in this case are powerful factors that weigh in favor of a retrial. The court, however, finds that there are several equally powerful factors which, when combined,
Hold on, let's hold
militate
it.
against ordering a new trial. In summary, these factors are the insufficient and inadequate account by the prosecution for the availability of its witnesses and trial exhibits.
This is where it falls down.
Witnesses and trial exhibits relied upon by the appellants, which tended to support their defense at their first trial, are now unavailable or cannot be accounted
It falls
for.
down. They're going
3,
to walk.
the appellant's trial in the Supreme Court was complex,
They're going to walk,
lasting
people.
64 days, and utilized a significant share of the court and the appellant's resources. Therefore, the time, financial costs, expense, and impact on the court's resources, as well as other cases in the queue awaiting trial, we find that this is significant and it militates against a new trial. 4, the psychological, financial,
They will
and
walk this evening.
medical effect that a new trial would likely have on the appellants who have already spent 13 years in custody, which is demonstrated by medical and other affidavit evidence. We look
Number one
at
alone is
the
not enough
medical
to hold
problems
up for a retrial.
relating to the appellant Palmer, which came through medical reports that stand unchallenged by the Crown and therefore speak to declining health in the penal institution. The court looks at the lapse of time between the commission of the alleged offense and the likely time in which a new trial would take place, which would,
No, bro,
in
they're going
our
to walk.
estimation, be at least 15 years. We find that to be inordinate. 6, the unjustifiable interference with the appellant's constitutional rights to a fair hearing within a reasonable
Number
time
5, so the court think
under
them doing
Section
enough time in
16 of the
prison.
Constitution of Jamaica, and the potential for that breach or interference, we should say continuing, if a new trial is ordered. We look at the potential prejudice to at least 2 of the appellants who, if convicted after a new trial, would be required to serve a longer term of imprisonment before eligibility for parole than that which was originally imposed upon them after their first trial, due to the
Another breach
operation of
again.
the statutory mandatory minimum for the offense of murder. The court looks at other factors which it did not see swinging the pendulum either way, and our judgment will explain it all. We find that the submissions regarding pretrial publicity did not assist the appellants. We find that pretrial publicity is such that you would have to prove that it is impossible to obtain a fair trial. And that question is one for the trial court. What the court did find coming out of the issue of pretrial publicity is if the mechanisms have to be employed as the Crown had argued, that would add to the delay of the proceedings. As we have said, we have looked at all the other factors, but we find by now, having weighed everything in the balance, that the countervailing the weight is against a new trial. Our judgment will explain everything in depth, but as we say, this is for the decision for you to understand what the court has done. Having regard to all the considerations the court has taken into account, we conclude that the interests of justice do not require a new trial to be ordered for the appellants, and we therefore make the following order. Judgments and verdicts of acquittal are entered in relation to the appellants.
Good evening. Vybz Kartel and his
We
co-accused
must,
have
on
just
the record,
been freed
thank our
in the
judicial clerk,
Jamaica Appeals
Mr.
Court.
Jordan
It
Jarrett,
was
Mrs.
promised
Monica
to
Harris
go in that
Mackenzie,
direction,
and Mrs.
given the
Nicole
amount
McLennan
of
and
wrangles
Miss
we see through
Chanel
the whole of
Hunter.
this. But
Had it not been for
hold on.
them, their assistants would not have been able to make the deadline given the workload of the court and the various things that we had to do over the past couple of weeks. So we give them the weight of the credit and we thank them wholeheartedly for their assistance. It leaves us to thank counsel on both sides for your spirited, maybe sometimes combative arguments, but we have learned tremendously from both sides, and we hope that the judgment will show that we appreciated the scholarship and appreciated the issues for resolution. So that is it. The appellants are freed.
Good evening. Good evening. Thank you for joining us. If you are just joining us, Vybz Kartel and his co-accused have just been freed in the Jamaican Appeal Court following the case sent back to the Privy Council by the Privy Council.
We've got passion, we've got determination. Like, and if we set our sight
To the Privy Council for a retrial, the Privy Council has gone through the assessment as to whether there should be a retrial or not. The Privy Council has, the Jamaican Appeal Court has decided today that it is not in the interest of justice to go for a retrial. What is this for the family of Lizard, and will there ever be justice for them, and is it all now dead? But who have lost and who have won? The people of Jamaica. The people of Jamaica who have mounted an expensive trial. The people of Jamaica who have mounted an expensive appeal in the Privy Council, and in the end will have to pay Vybz Kartel and his co-accused legal bill, as well as it is quite likely that there will be lawsuits coming, possibly not. The only loser in this is the people of Jamaica, who've footed a bill for justice, who from the start was tampered by police, prosecutor, and in the end, a crooked judge who sent a tempered jury into deliberations. Thank you all for joining us. We never planned for broadcast this evening because me did that park and me never give up my park time for this. But being as me back home little before it start, me say, all right, me go do like a flanke about it. But if the Jamaican Authority had a good case against Vybz Kartel and his co-accused, it was been botched from the start with the tampering of his mobile phone when it should have been in the custody of evidence. The jury tampering, which the court was aware of and should have discharged the jury. A whole load of waffle. The prosecutor agreeing to continue with a tampered jury, even though the overriding decision is with the judge. But it all turns out that this was all, I wouldn't say a sham, but justice messed up. This has shown us that a lot of young people in our country may be in this system not being able to receive a fair trial. The great question I would want to pose to the Ministry of Justice this evening, given how all of this have turned out, will you pull the appeal against Paula's unconstitutional extension? Will you pull that appeal and allow the DPP, who have wasted millions of our money on this case, the DPP must go this evening? The case, Ministry of Justice, is there any integrity in justice this evening, the Minister of Justice and the Attorney General should pull that appeal they're taking forward to aid Paula's extension to stay on longer. Paula has openly told us, I have done it before. It is not the first time. How much people are in custody because they did not, in prison, because they did not get a fair trial? If there's any integrity in justice, this case ought to be pulled and Paula must go. We cannot waste any more money on a crooked DPP. What more no good again? Me I tell you, beat and teach. Over they must burn down, you know, how them celebrate and carry on. But if any globalist there from Portmore and the one send with some image or whatever without mind, but it is a disgrace for the Jamaican justice system. Yes, Kartel and his co-accused and their fans and family are rejoicing. On the other hand, it is a sad day for Lizard mom and family, no doubt. It is also a dreadful day for the Jamaican justice system. From February this year to now, when the case started in the Privy Council to the judgment date in March, the Jamaican justice system, the corruption, the ineptitude, the incompetency of the Jamaican justice system has been laid bare in front of the world. Today, it shows that we have a DPP who has been incompetent, inexperienced, political, and not fit for office. The Director of Public Prosecution, Paula Llewellyn, and the Attorney General, and the Minister of Justice must pull that case that they are appealing against Paula's extension. It is an absolute disgrace. Our justice system is an absolute disgrace. I hope this may overhaul it. I hope this may even show us more that we need to push for the Caribbean Court of Justice, because under the circumstances, I do not trust the Chief Justice of Jamaica, nor do I trust the Director of Public Prosecution. Because if it was left to the Supreme Court of Jamaica, if we were a republic, this case would have been done and dusted. Going to the Privy Council exposes the corruption of our justice system. Parler should go this evening. I want to thank you all for being here. This is a short broadcast. It was just to broadcast the judgment and to analyze it. However, you know my slot is in the next few hours, so I will definitely be back in the next 2 hours and a half. Thank you all very much for being here with us this evening on the Vybz Kartel Freedom broadcast. Thank you all for being here. Join us back at 11 p.m. UK time. We're going to have to work out that in our foreign time. Thank you and good afternoon from Global TV.